Are we ready to?
¿Listos para empezar? Los taquígrafos, intérpretes.
Interpreters on the wrong channel.
Done. Understood.
No?
See, it scared me, so did I sound scared?
Are we ready? Is all technical? Okay. Then we will proceed with the fifth day of the hearing in the case David R. Aven et al. Versus the Republic of Costa Rica. We will continue the examination now of Mr. Luis Ortiz, the expert witness that has been submitted by claimants in respect to Costa Rican law. Good morning, Mr. Ortiz.
Good morning.
You concluded yesterday your presentation with respect to the principles that you deem fit to describe with respect to primarily Costa Rican administrative law. We appreciate your presentation. Now we will proceed with the examination, and as I identified yesterday, there will be some questions presented to you by counsel to the Republic of Costa Rica. I'm not certain whether whether you did yesterday confirm your report, whether that has been taken care of, which I don't recall that it did. So perhaps counsel to claimants may simply wish to make a brief direct in this respect, to be followed by the examination of respondent. Thank you.
Thank you, sir. You anticipate a point I had intended to raise, but thank you for that. For the sake of the record, Mr. Ortiz, could you take the file to your right? Now, you've already given your confirmation that you will only give truthful answers to questions and truthful evidence in these proceedings, so we do not need to go through that, but we do need to confirm that the report that appears before you is indeed your expert witness, your expert report, and that give you the chance just to check that it is in the correct form, and you have no revisions to make to it. So I'd like you, first of all, you see the document that's at the top of that file. If you could just, it's a long document, I know, but if you just flick through it to check whether it appears to be a good copy of the expert report you'd submitted earlier in these proceedings.
Yes, Counsel, it is. I confirm it is my report.
Thank you. Do you have any changes, amendments or corrections to make?
Nope.
Could you look at page 69 of 69?
Mm-hmm.
Is that your signature?
That's my signature.
Thank you. No further questions.
Good morning, Mr. Ortiz.
Good morning.
My name is Amal Bushanaki. I have a few questions regarding your presentation yesterday and your report. So yesterday you referred to the concession that claimants are including as part of their investment, and you mentioned the case of Efsher v. Peru. The Republic of Peru, the Inter-American Human Rights case. That case, just to clarify, are you relying on that case because you consider that it is relevant to the assessment of the ownership of the claimants in relation to the concession or the legality of their ownership. Could you just briefly clarify the relevance of the case, please?
Okay, first of all, I don't think there is any illegality in the concession.
I'm so sorry to interrupt. I just really, if you could focus your response on the relevance of the case.
However, if hypothetically one could consider that there was a time where Costa Rican did not own a 51% of the shares, I think that case is totally applicable because the case was Ifcher Bronstein was a citizen of Israel. In Peru, there are laws that prohibit foreigners to own television channels. So Ifcher Bronstein converted into a Peruvian in order to be the holder of this television channel. However, this television channel issued information on Vladimiro's
I understand. So you're I'm sorry. So in fact, but isn't the focus of that case the issue, the fact that the Peruvian state granted him nationality and then withdrew his nationality after he had relinquished his Israeli nationality to acquire Peruvian nationality? Wasn't the focus of that case really the legality of that aspect of what happened?
The rationale of that case is that the Inter-American Human Rights Court established the rule that in regards to human rights, the only discrimination that sovereignty can be authorized is regarding political rights.
Are you suggesting then that the... Oh, I'm sorry.
Sorry, Mr. Ortiz. I think that your interpretation is somewhat optimistic. In Ifcher Bronstein, the subject of political rights was not covered. Ifcher Bronstein was a case where precisely because the difference between the treatment of nationals and foreigners regarding television property was legitimate, Mr. Bronstein's nationality was withdrawn to make him become a foreigner and take the television channel away. But the court did not cover the subject of political rights nor the valid differences between nationals and foreigners. The first case, I don't know if it's the only one, where the case did cover conceptually the subject of discrimination was in a consultative opinion regarding Costa Rica, number 4, by the way, where it established that the differences in treatment were not necessarily discriminatory, but only if they went against the nature of things. If they were disproportionate, these are subjects that come from administrative law, and reasonable. But differences in treatment between foreigners and nationals, that can happen without that necessarily meaning that one is violating the non-discrimination rule. Here, for instance, we have not discussed, as far as I can recall, the subject of Costa Rican law, which ensures that owners of real estate in the coast or near the borders be Costa Ricans, be Costa Rican nationals, because that has its rationale due to state security reasons, so it's not necessarily discriminatory. The difference in treatment between nationals and foreigners can happen outside of the ambit of political rights, and as long as they're not irrational, contrary to the nature of things, and according to the court's jurisprudence, they are perfectly legitimate. And in this case, in the case of Mr. Bronstein specifically, this subject that you mentioned, and yesterday, by the way, I decided to check on it, it was not mentioned in that decision. This is a decision that I've had to handle a lot during my academic and professional career. And since I was at that court, I was always very interested in its case law. And there, what they stated was that Mr. Bronstein, arbitrarily, his nationality had been withdrawn in a very characteristic case of power deviation. Or in order, by taking away his nationality, to obtain that result. As for the rest, and I would like to add from the factual point of view, the videos were shown on television, that is the ones on Montesinos, shortly before the fall of the president. There were some news that came through the Bronstein channel that were not to the liking of Mr. Montesinos, but they're not what they were called the Vladivideos. But this is something that is actually anecdotic as far as the merits of the case are concerned.
An acceleration, a
I'm
clarification.
sorry, interpreter overlap. Could you repeat that?
Okay, may I?
¿Puede repetir?
Please, if you want to make any statement.
Yeah, I agree with you, Mr. Niken. However, my interpretation of that ruling from the Inter-American Human Rights Court is that it implicitly states that there shouldn't be any discrimination between foreigners and nationals dealing with the freedom of enterprise. And even more, our Constitutional Court has indeed issued a resolution specifically regarding the rule of the 51% that has to be on Costa Rican citizens regarding the exploitation of airlines. So in our country, there is, in fact, a precedent.
Precisely, Mr. Ortiz, regarding that precedent, that's the TACA case to which you referred yesterday, right? Correct? You have to say correct for the...
Yeah, correct.
And so in that case, wasn't it the case that what the Constitutional Court opined on was that the rule on the ownership was implemented in a regulation rather than a law, which in fact is the case in the case of Las Olas, because the limitation, as you know, for the 51% ownership on coastal land is in the law.
Mm-hmm.
And my understanding, but then and it is my understanding that our Costa Rica's expert on administrative law agrees, is that case specifically related to the fact that it was the 51% ownership rule was not included in the proper instrument. Wasn't that the case, rather?
That was part of the rationale of the ruling, but the other part, it's a substantial rationale on the discrimination between foreigners and nationals.
So your position is that the case is relevant to the ownership of coastal land in Costa Rica.
Yes, it is.
Now, moving on to your opinion regarding the 15-day rule, the 15-day deadline that you mentioned, can I take you, please, to your tab number 1 in your binder, which is Article 99 of the Organic Environmental Law.
Mm-hmm.
So can I ask you to read it quickly? Or I can just read it. It's in the event of a violation of the environmental protection, of environmental protection regulations or harmful conduct to the environment clearly established in this law, the public administration will apply the following protective measures and penalties, and then it lists a series of measures, including restrictions, partial or total, or order to immediately seize the acts that give rise to the complaint. Correct?
Mm-hmm.
Do you agree that this rule does not set out any specific time frame other than a reasonable time frame?
Yeah, this rule does not.
Now,
This specific rule.
okay, and then
And if I may, this refers to penalties, what is different to interim relief injunctions.
but it is the rule that refers to, and I read the Spanish, medidas protectoras, yes? So it is penalties and protective measures, right?
Well, the title says administrative penalties. That's
But-
what the title of the article says.
The title of the article does, but the article itself does refer to protective measures, does
I
it
don't
not?
interpret. I don't interpret it.
I'm
that
just
way.
asking about what the
Excuse me, if the
articles.
witness could wait for the question to be fully asked.
I'm asking precisely about the text of the article itself. It does refer expressly to protective measures in addition to penalties, right?
Yes, it says protective measures.
And sancciones, right?
And sanciones.
So it does provide for both.
Exactly.
Now, you refer in your report, and it's the article of that I'm going to refer to is in tab number 2 of your binder. And in there we have Article 2.1 of the Public Administrative Law that reads that the rules of this law which govern the activity of the state shall also apply to the other public entities in the absence of special rules for them. Correct?
Yes.
Now, would you agree that the rules on environmental protection do constitute special rules and special applications?
Could
This.
the witness please answer out loud, audibly, instead of uh-huh?
He
Yes.
did.
This article refers to another hypothesis, absolutely. If you read it carefully, it says entes públicos. Entes públicos. How I explained yesterday,
Public entities.
Costa Rican government or public administration is made up of the Costa Rican state, that it's a persona jurídica, and other entities. These other entities might be the municipalities, the autonomous institutions, and other public entities. Setena is not a public entity. Therefore, this article does not refer to Setena. Setena is part of the executive branch, part of the MINAE, of the environmental ministry. So this article does not apply to Setena.
Okay. Now, moving on to your paragraph 31 of your report. You refer to Resolution 2004-09232 of the Constitutional Court, which you say affirms the principle of a reasonable period, a short period of time after an injunction is issued by a public entity, right?
Yeah, sure.
And you say in paragraph 32 of your report that the case law on this matter has evolved to determine that the relatively short period of time is 15 days, correct?
Correct.
Now, you cite to a number of cases, including this Constitutional Court case, and then the one to which you refer in paragraph 31, and then to other cases, 4 cases, that you say support the position that there is a 15-day rule in order to follow on the issuance of an injunction, correct?
Correct.
Would you agree that none of those cases relate to environmental law matters?
Yes, I agree.
Yes, so you agree that none of them, okay.
However, there are cases.
I understand that if there are cases that are relevant to environmental law, then wouldn't you agree that they would have had to be in your report in order to fully inform the tribunal on the state of environmental law on this issue?
Not necessarily, because the general principle, these rulings from the Constitutional Chamber do not refer to a specific matter of law. They refer to every governmental entity. It says clearly.
Mr. Ortiz, my question was about the case law that you could find in order to support your position that in the environmental law area and in the practice of environmental law in Costa Rica, this 15-day rule applies in the same way as it applies for telecom regulation and the other areas of administrative law to which you refer.
Sorry to interrupt, but
support.
just because Ms. Buchanaki is interrupting the witness on several occasions, just to clarify, your question, Ms. Buchanaki, was if there are cases that are relevant to environmental law, then wouldn't you agree that you would have to be in your report in order to fully inform the tribunal on the state of environmental law on the issue? So your question actually refers to the state of environmental law, not just the cases. Mr. Ortiz was attempting to answer the question as you put it, and then you cut him off. I think it's going to work best if he is allowed to give his answers as fully as is appropriate.
Right, and my question was really about the case law in support of the state of environmental law, which, in the interest of time, I think, it would be best to encourage the witnesses to address the questions rather than expend. You had an hour yesterday to present your view of environmental law in general.
Mr. Chairman, may I clarify?
Yes, we explained yesterday you should first respond the question. If there is need to clarify, you may thereafter make a clarification. There might be a point in time when the line of questioning of the counsel to respondent may require that you address other questions. Your answer may be in subsequent questions, but if that is not the case, I'm certain that counsel to claimants will allow you to make proper clarifications in due course.
Thank you. Now, so my question was really about the case law because, as you are aware from reading his report, the expert for the Republic of Costa Rica does not share your view that this 15-day rule applies in the practice of environmental law in Costa Rica. And so my question to you was that we observed in your report that all of the cases on which you rely relate to other areas of administrative law. And then second, that to the extent that you were aware of cases that support this practice that you allege exist also in the administrative law field, why would you not include them in your report or in your presentation yesterday, since you had an opportunity, in fact, to address Mr. Jurado's report?
Well, may I ask what's the specific question?
The question is, to the extent that are you opining that these cases of these cases from, for example, administrative environmental tribunals, the TAAs, exist where this 15-day rule is implemented and as an obligation, the way you are saying that it exists in other cases? And then if those cases exist, why would they not appear either in your presentation yesterday or in your report?
Okay. That is because I considered it unnecessary, as the rationale of the Constitutional Court relates to governmental entities. It doesn't matter what is the substantial topic. It doesn't matter if it's child protection, telecommunications, consumer law, competition, or environmental law. It relates to every governmental agency. And CETENA is a governmental agency. The TAA is a governmental agency. SINAC is a governmental agency.
Thank you. And so this is a point on which obviously the experts are in disagreement. Now, moving on, assuming for the sake of argument that a provisional measure is issued and that no process is initiated within the 15-day period, and I am placing this hypothetical in the area of environmental law, to be clear. What are the avenues, what are the remedies for the administrador, for the a developer, say, for example, in a situation like this, under Costa Rican law?
He may request the reversal of the interim relief injunction before the same agency that ordered it. He may also file a judicial review before the administrative jurisdiction, or he may file a writ of amparo before the constitutional court.
Okay. Are you also, and you are familiar with the measures of that are called contra cautela before the tribunales administrativos ambientales?
Yes.
Okay. And this is also a remedy that is available to a user of the administration who would have been denied this 15-day rule that you allege, right?
No, it is not a remedy. The contra cautela is a condition in which a governmental agency or the administrative jurisdiction may order an interim relief injunction. And what it tries to do is to balance interests. And let's say a third party requests an interim relief injunction to CETENA on another party, on the developer. Then CETENA may request the party that is requesting the injunction to issue a contra cautela in order to protect the interests of the developer. But it is not the person that is being subject to the order of the injunction that has to render the contra cautela.
What I mean is, isn't it the case that if you are the subject of an injunction, for example, if you are aware of, if you are the subject of an injunction that suspends the works on your property, don't you have the avenue of going to the tribunal and asking for a counter interim measures that would suspend the suspension? Isn't that a proceeding that is available under Costa Rican law? It was my understanding that it does exist.
No, you may challenge the interim relief injunction, but it is not a suspension of the suspension. I mean, it's not an injunction of the injunction. Either the injunction is reversed or it is not reversed, or it may be changed.
So
but it is not a suspension or an injunction.
So
it is a reversal.
Okay, so it was my understanding that the avenue existed under Costa Rican, in the practice of Costa Rican administrative law. Or maybe that's not a type of practice that you have experienced, correct?
As I explained, what you're talking about, the contra cautela, it's used but in a judicial avenue where there are most of the time three parties. Then one of the parties requests to the tribunal to issue an injunction, and the tribunal may order the injunction, but ordering as well to this third party, the claimant or the party that is requesting the injunction, to render a contra cautela to protect the party that it's been subject to the injunction.
Thank you. Now, yesterday you stated that that environmental law was I'm quoting from the transcript that we received last night. It's not the final transcript, but just for convenience. Administrative law qualified by environmental law. I think in Spanish you said adjuntivo al derecho administrativo. You said that environmental law was a form of administrative law. It qualifies administrative law, but are we in agreement nonetheless that the principles that govern environmental law are principles that are specific to environmental law and that are not found in other areas of environmental law, correct?
I agree. However, as I explained yesterday, these principles are of substantial law, not of procedural law. Procedural law, the law that applies in procedures is the administrative law. So, yeah, indeed, as we have tax law, well, tax has its own substantial procedures, substantial principles, but the procedures are governed by administrative law or
Correct.
public law
And
or
those-
consumer law or competition law.
And just to clarify, I meant to be found in other areas of administrative law, obviously not environmental law. But so, and in those cases, those substantive principles that govern the specific area, in our case, environmental law, they're governed by their own rules of they're interpreted according to their own facts and sort of the creative body. For example, you refer to the principle of precaution. It's a principle that has developed into a sort of a universe of implementations and interpretations, correct?
Correct. And dealing with injunctions, the only difference with the other areas of administrative law is that the principle or the requisite to order an injunction, which is to have a grave impact.
And I'm very sorry to interrupt. It's just I have moved on from injunctions. I was just trying to ascertain sort of that what we're talking about is we're talking about a series of principles of environmental law that are specific to environmental law and that are sort of that have their own universe of rules and interpretation, correct?
Yes, so my answer would be yes, I agree. Each
Okay.
area of law, administrative law has many areas, many specialities, and
Yes, and-
there are in each one substantial law principles, but not procedural principles, which are all governed by public law because that's a guarantee
That
for
you've
the
already
citizen.
made this point. Thank you very much. Okay. And so, would you agree that then, in terms of the environmental law in Costa Rica, there was a constitutional reform in 1994 that really defines the sort of what environmental law in Costa Rica is today, and that these principles that exist that you mentioned yesterday derive from this Article 50 in particular of the Constitution? That is a point with which you're in agreement with Mr.
Yes, there was a
Fuentes.
reform to Articles 46 and 50. I would say those principles do not derive from those articles, but the Constitutional Chamber, using, for example, the Rio Declaration and many other treaties and the Constitution, has derived those principles.
Thank you. And so, in paragraph 76 of your report, you quote the principle. You mentioned the principle of precaution, and you indicate that, in accordance with that principle, there is an inversion of the burden of proof.
I'm sorry, what page?
Paragraph 76 of your report.
Yes.
And would you agree that a key practical implication of this principle is that developers bear the burden to prove that the environmental impact of their works does not affect a protected area such as wetland or forest, for example?
I agree that is the case when the preventive principle has not been applied.
Okay, I'm so sorry. So that means that you agree that, say, the principle implies that a developer has a duty to prove, or certainly to make a fair representation of any areas that might be protected areas on its property, correct? I'm talking at the very beginning. No protective measures, nothing is in place yet.
No, I don't agree with that interpretation.
Okay? So you don't agree that when a developer makes a first filing to the administration, it has a duty in accordance with the principle of inversion of the burden of proof, that to make a truthful representation of the conditions on the land?
The precautious principle does not apply in those cases. The precautious principle applies when the project is in execution. The principle that applies when there are going to be studies like the environmental viability is the preventive principle, that it's totally different. One applies in one stage of the project and another applies in another stage.
And then regardless of the principle of precaution or the principle of good faith, would you nonetheless agree that that is a duty of the developer in Costa Rica? That in Costa Rica, a developer has to make a truthful and exhaustive and thorough representation of what the conditions on the land are when he or she makes a filing with an environmental authority?
Yes?
Okay. Now, with respect to the inversion of the burden of the proof, and once proceedings or once a process is ongoing, would you agree then that there is this that it is for the developer to prove that it has not breached environmental law?
If we did not apply the preventive principle, that is, if we don't have studies or, for example, the environmental viability, then that is the case in which that principle applies. I mean, when someone innovates and becomes, I don't know, he's gonna talar, he's gonna cut corn plants, let's say, and there have not been any reports or any environmental studies that have already confined the possible damages, then those are the cases in which the precautious principle and the inverse burden of the proof applies, not when the environmental viability has been already granted, because precisely you have already confined the possible damages. The precautious principle and the burden of proof applies when there is no certainty of the damages that a new activity can cause.
But then, do you agree that the viability application, the environmental viability application, it includes a sworn statement that the conditions on the land are what the developer says they are, correct?
Yes?
And so the administration's role in granting the EV, the environmental viability, is not to second guess what the developer is representing. There is a principle of good faith that is assumed, and that the developer is expected to comply with. That's correct, yes?
Yes.
So So, would you not agree that once this principle of good faith, if there's evidence that the principle of good faith has not been complied with by the developer, and that the EV has been obtained in a violation of that principle, would you not agree that it is for the developer to demonstrate that the conditions on the land are in compliance with what its original D1 application was?
That is a complete hypothesis, but under that hypothesis, the first thing that the governmental agency or SETENA would have to do is to nullify, to declare null and void the environmental availability permit. That is the first thing it has to do, because it is valid.
Okay. Thank you. So, now, I'd like to move on to your statements yesterday about fragmentation, and also about the easements and the sort of the regulations on easements in Costa Rica. So can I take you to paragraph 108 of your report, please? So in that paragraph, you refer to the regulation for the national control of fragmentation and urbanization, which is in tab 10 of your binder, if you'd like to look at it. I'm just going to refer to some articles. So this regulation and Article Roman capital 2.1 of this regulation authorizes the segregation of land into lots, provided that the lots have access to a public street. I'm not quoting verbatim, but that's generally what the rule is, correct? And that if a, I'm sorry, I'm just finishing and then I'll let you confirm, but then if it's not possible for the lot to have access to a public road, then an easement needs to be created. So it's just Article 2.1
Yes,
of the regulation. I mean, that is a fair representation of the article, correct? Or would you prefer that I just read the article?
yes, just a second. Can you repeat, please?
So I'm just going to read the article, that way we don't have to. Lots in front of an easement, that's the title of the article, all parcels resulting from a segregation will have a direct access to the public road. In special cases, INVU and the municipalities can admit the subdivision of lots through easements, provided that the following rules are complied with. And the easement shall be accepted in special lands where, because of its location or dimension, it can be demonstrated that it was impossible to segregate without an adequate access to existing public roads. And it goes on to the last sentence, which is preferably these easements should be used for cases when there is existing housing in the lots.
Yes,
right?
that's what it says.
Okay, so you would agree that according to this language, an easement is a rather exceptional mechanism under Costa Rican law. That is, that the segregation happen, not exceptional in terms of how often it happens, but rather exceptional in terms of, it says, in special cases, right?
Yes, that's what it says. However, it's very common in Costa Rica.
Yeah, and my question was exceptional in the legal term, not in the sort of how often does it happen. And so, are you familiar with the configuration of the Las Olas site? And I'm not going to go to a factual question, but just show you the map of. Can we put the map on, Mike? Yes. Just so that you have a view of how the property is structured, but I suppose that you've already seen
Yes.
it, right? So the property is divided in three large areas, which there is the area to the south, which is the concession. Then there is a large middle area, which is the condominium, and then to the west, where you see the yellow circles, is and all this line along the road there is an area that the claimants refer to as the easements. So if we can get maybe the closer map, yeah. And so the easements are shown there more closely. So the roads that appear in there are internal roads in the that go into the easements. You do agree that they do not go all the way to all the lots, right? So not all the lots are covered by these internal roads.
I cannot answer that question. From that map, I would have to be in the site, and I mean, I'm not an expert to decide on that.
It's a visual. The road doesn't seem to go all the way. So provided, assuming that the map is correct, would you say that it goes all the way to the end of the easement?
No, really, I can't say
Okay.
from the map.
Now, the under Article 2.1.3 of the same regulation, the number of lots into which an easement can be segregated are limited to 6 lots per easement, correct?
Which article? I'm sorry?
2.1.3.
Okay. What it says here is that the lots should have all the minimum services existing in the area.
It says in case frente a servidumbres solamente se podrá segregar un máximo de 6 lotes.
Oh, okay. That's 2.2.1.3. Mm-hmm.
I'm sorry, yes.
Mm-hmm. Yes.
So in the case of Las Olas, the easement, this area that the claimants refer to as the easements, is composed of 9 actually contiguous areas that they characterize as easements. And cumulatively, this area comprises 72 lots, all belonging to the same companies controlled by claimants and to which the claimants refer to as the enterprises. Now, let's say if the claimants had wished to comply with the regulation, and if they had wished to consider that this accumulation of easements and these 72 lots really constituted an urbanization more than easements, and I'm not asking you to say that that's what they did. I'm just asking you to consider it as a hypothetical. If that's what they had done, if they had gone to the INVU and the municipality with an urbanization plan rather than an easement, what would have been their the steps that they would have had to take before the various administrations in order to get their project going on these 72 lots?
I really don't know. It's a hypothesis, and I would have to look with enough detail, with sufficient detail, what really could have happened. But I cannot imagine.
But could you say a developer that starts that submits an urbanization plan what are the type of steps that they have to go through? What type of authorizations do they obtain? Are you familiar with that?
No.
So you're not familiar with what developers have to do when they start a project in Costa Rica?
It's probably, yeah, of course I'm familiar, but I mean, if I had to tell you all of the permits and all of the procedures that they have to do, we will last here all day long.
Would you say that they would have had to get an environmental viability from Setena?
It would depend on the conditions. As I told you, when the project was carried on, well, when the easements were carried on, there were several
And I'm asking you
Setena
to-
resolutions.
Thank you. And I'm asking you to consider the hypothesis where we're not talking about easements, we're talking about
Yes.
an urban development plan with 72 lots. For a plan like that, would you have to go to Setena and obtain an environmental viability?
I cannot tell because it depends on the conditions of that urbanization. It depends on its location. It depends on many elements. I mean, it's not a recipe.
Have you ever seen a development of 72 lots in an area such as this one, and with this size of developments that goes forward in Costa Rica without obtaining an EV?
Have I seen?
Are you aware? Have you? I mean, you that's an area in which you practice, correct? I mean, is that something that have you ever heard of an urban development of this size that goes forward in Costa Rica without obtaining an environmental viability?
I have not seen, and I have seen. I mean, in both cases, I have not seen or not seen. That's the answer.
But it is your testimony that for an urban development of this size with that many lots, you could go forward and initiate works without obtaining an EV, an environmental viability.
No, my testimony is that I would have to look exactly to the conditions in which it is being developed because it depends of many elements.
Okay.
And Setena, once again, Setena has issued over its history a lot of resolutions in which it has exempted certain projects from the EVs. And a clarification is that I don't practice in real estate. Once again, my expertise is in administrative law.
Right, but this is a matter of environmental law, really, because if the question is, under Costa Rican environmental law, can you develop a property of that size without conducting an environmental feasibility study and submitting it to Setena? Is that something that you could do in Costa Rica?
Once again, I cannot answer the question under those hypotheses. I would have to look at the case and its elements.
Okay. Now, wouldn't it be also the case that for a development of this size, an urban development of this size, you would have to dedicate, my understanding is 10% of the area to some form of public park, or that you would be dedicating to essentially to the municipality where the urban development takes place?
I understand that if it's an urbanización, that would be correct.
Yes, and that's what I'm talking. I said an urbanization plan.
Mm-hmm.
That was my question. So that would be correct.
Mm-hmm.
Now, I'm sorry. In paragraph 109 of your report, you said that there were no steps or authorization to be sought by claimants if, and I quote you, simply in order to fragment the easement and create the easement lots.
Paragraph 109.
Yes, 109.
Yes. Yes.
So essentially you're saying as long as it was just to create the easement, there was nothing to be done, no EV to be obtained. Now, would you say that 9 contiguous easements with a total of 72 lots, would you, in your opinion as an expert in administrative law, would you consider that that falls within within what the law intended when it's provided for these easements?
I'm sorry, I did not understand the question.
What you have before you here is 9 contiguous easements with 72 lots altogether, with a plan to develop the easements into, into building, houses. Would you say that this project, as I'm describing it to you, falls within the scope of the authorization, which you explained was exceptional, of an easement?
I'm sorry, but I still don't get the question. I'm not understanding the question.
So you wouldn't think that in order to evade CETINA, the CETINA environmental viability, the claimants would have subdivided this whole area into 9 easements? That is not something that you would say could be said to be true in this case?
No.
Okay.
At least I don't have the elements to say it or neglect it.
Okay. So still at paragraph 109 of your report, you say the developer will need an EV, an environmental viability, to be able to make use of the fragmentation. That is, an EV will be required prior to construction.
Yes.
This is still, and you said that yesterday as well, correct? Now, could you please take a look at paragraph 278 of the claimant's memorial, which, it's on the screen, sorry. And I'll just read it to you. In the circumstances, it was perfectly legitimate for the claimants to have carved out the easements and subdivided the easement section into lots without obtaining what would have been an unnecessary environmental viability. And then I follow paragraph 280. Further, as Mr. Mucio and Mr. Bermudez explained in their witness statement, based on their extensive experience in dealing with this complex real estate developments in Costa Rica, it is common for developers to divide their projects into stages and apply for the relevant permits and as and when those stages are to be developed. Then I would like to take you to tab 11 of your binder. And if you go, it's the transcript, the provisional transcript of claimant's opening statement. And if you go to lines 17 to 22 of page 128. And so here, Mr. Byrne was speaking about, again, this area, and he says, but this type of fragmentation is entirely consistent with Costa Rican law and Costa Rican practice, especially where, as here, there are different phases of construction. Now, and then last point, I'm taking you then to your tab 14, which is paragraph 60 of Mr. Aven's first witness statement.
60?
60 of his first witness statement. And there he says there would be 5 phases of development. Phase 1 would be the 72 lots coming off the easement, going into the easements going into Las Olas, and then he describes the other phases. Now, could you please go to Article 94 of the Biodiversity Law, which is the next tab, tab 15, please?
Article 99, 98. What article, pardon me?
94 of the Biodiversity Law. It's tab 15. It's Exhibit C207. And the article reads, the environmental impact assessment as it relates to biodiversity law shall be undertaken in its entirety, even when the project is to be developed in stages. You are familiar with this article,
Yes.
correct? Yes. Then one last tab I will take you to, please, for this question, and it's tab 13, please. That is a resolution of Setena, which states in its paragraph 2, for example, the technical criteria determines that is one and the same. So it was a determination regarding a project with adjacent properties. And they say that the technical criteria determine that it is one and the same project involving 3 adjacent properties with the same developer and for similar works, namely the movement of earth to provide access to a road, being such that this Secretariat cannot permit, for the sake of other interests or factors, the violation of the environmental legislation permitting a separation, which I think is probably here, a segregation of the environmental assessment in applying less rigorous environmental assessment instruments or less environmental significance to the detriment of the environment and in violation of the law. Now, in light of these rules, would you continue to say that these 9 adjacent easements for which Claimants has consistently confirmed that they were going to be the object of construction and that they were part of the overall project, would you continue to maintain that that they are not, that they don't constitute, that these easements are not in violation of the biodiversity law, and that there was no obligation to submit for an EV in this particular case, an environmental viability?
Yes, for at least 3 reasons. The first, bear in mind that this resolution from Setena is from 2015. As I told you, when the easements were being issued or prepared or concreted or executed, there were at least 4 resolutions from Setena that exempted certain projects from EVs. Which projects? Well, what those resolutions did was that they technically defined what type of projects were exempted from that. So Setena might have had, as it is common, changed its mind, and this is 2015. Second, because although Article 94 says what it says, the environmental organic law also states that the EVs are necessary to initiate activities or projects. Therefore, if the activity, which is construction, or the project, which is construction, and we bear in mind that in that time the developer probably didn't know if he was going to really develop, if he was going to build condominiums or houses or another club, if he has not initiated the activities or the projects, then the hypothesis that the organic environmental law establishes to get an EV was not complied with, was not being complied. So yes, I maintain my my position.
Okay, just to clarify that, to make sure I understand you correctly, are you saying that this Setena resolution doesn't apply because it was issued after the project was initiated?
Not only because of that, but because we would have to analyze the case by case.
Of course, but however, the assessment that Setena is making here is simply, Setena is simply interpreting Article 94 in this resolution, and Article 94, if I'm not mistaken, was introduced in the biodiversity law in 1998. So this is an article that has existed in Costa Rica for many years before, correct?
Indeed.
Yes. So, so really, the fact that the Setena interpretation that I'm quoting to you is from 2015. It might be that there are Setena resolutions before that that I haven't quoted, but the fact is it was interpreting a provision of the law and a practice that existed since way before that, correct?
No, I wouldn't say that that practice existed a long way before, because once again, during the execution of the easements, there were at least 4 resolutions from Setena that exempted certain activities and certain projects.
Precisely, going back to this point, I'm referring really to the fact that when this project was submitted to Setena for environmental viability, you do agree that at that time, and based on the claimant's consistent statements, the project was already designed to include the easements, correct? And the easements were in fact, per Mr. Aven's testimony, phase 1 of that project. So what I'm not placing myself in, at a point in time where there may or may have already been Setena resolutions. I'm placing myself at the time when claimants have approached the Costa Rican authorities to obtain authorization on their project. At that point in time, they parsed out the property in order for them to only apply for the condominium part, and they left the easement part out. So at that time, there was no Setena resolution. There was only this project that was initiating. So my question here is that Article 94, even absent any interpretation from Setena, is fairly clear. Wouldn't you say that according to the obligation of good faith of the developers, there was a major omission, to put it nicely, to not include the easements in the Setena application, in the G1 form that was accompanied by a sworn statement by claimants?
What I can tell you is that it's a valid interpretation that these easements did not require an EV. And also, it is important to say that these easements are not made liberally. These easements need the visado municipal, and the municipalities also have environmental competence or empowerment. So if the EV was indeed necessary, the municipality would have neglected the visado municipal. Also, these easements had to go through INBU. And if the EV was indeed required and everybody was in agreement that it was required, then the INVU would have neglected the avisado. The municipality would have neglected the avisado. And after that, these easements have to be registered in the Catastro Nacional, the National Cadastry, and the public registry. So, I mean, it was not an interpretation only of the developer, but of the municipality and INVU.
And I'm focusing on the conduct of the developer solely because, in fact, under Costa Rican law, the burden is on the developer. As you explained, before anything else happened, the burden is on the developer to be truthful, so to the administration. So the reason why I'm focusing on that, and before they approached the municipality, before they approached INVU, it wasn't their obligation to look at this property, to look at the fact that they knew from the beginning that, in fact, the construction on the easements was phase one, as Mr. Aven says in his witness statement, of the development of this project, and then include either, if they really thought that this needed to be a separate section, either include the submissions for the EV for everything, and then several submissions, or just the condominium, or one EV for everything. But wouldn't there be? I mean, wouldn't you agree that given the burden that was on the claimants under Costa Rican law at that time, wouldn't you say that not having done so has misled the administration substantially?
I think you're confusing the burden that the developer has to his right to a valid interpretation based on Setena rules or Setena resolutions during the time that the easement was executed, and that relying on that if the environmental viability had to indeed be obtained, the municipality would have had to have raised a red flag and neglect the permit for the easement, or INVU, or the National Cadastre, or the National Registry. I mean, once again, if you need an environmental viability or not, sometimes it's very easy to determine, but it is not a recipe. There are many gray zones in which you can interpret one way or the other. So my interpretation is that this was a valid and reasonable legal interpretation by the developer.
So, I will be concluding shortly, but I just wanted to clarify something. How familiar are you with the facts of this case?
I am familiar with all that I have been able to see and interiorize from the whole file. I was not present. I had no participation during the project, and I don't know if the project was indeed presented to the municipality, or if it's the intention, or if it was the intention of the developer. I mean, I took knowledge of this case in July of this year, and what I have seen is all the administrative, all the file.
Mr. Ortiz, but you are aware of the fact that one of the disputes here is that claimants, certainly Costa Rica's position is that claimants have, through sort of a doctoring of their submission, their initial submission to Setena, that they have concealed the existence of protected area on the site, correct?
Of course, that's why my initial presentation was, my first point was your teoría del caso, your theory of the
Yes.
case, is that the permits all are null and void because there was defects on.
And in fact, that is not exactly correct. And I won't go there, unfortunately, because
Well, it's what it says in paragraph 709 of your counter reply.
and it's null and void. So these permits were enough. They were not appropriately obtained. Today, these permits are suspended. So, just to clarify, so in terms of Costa Rican law, the Costa Rican law analysis is not that they have been voided or that they have been annulled. They're suspended. But that was not my question. Was the protected areas? I just wanted to mention to you, in this case, the disputed, the undisputed protected areas are in fact surprisingly on the easements where the yellow circles are. Would you maintain, though, that you don't think that there's a possibility that in submitting their initial filing for environmental viability, somehow the claimants were trying to circumvent Article 94 of the biodiversity law by not submitting a full EV in this case?
Once again, my response to that question is that it was a reasonable interpretation of the law. It is common in Costa Rica. It is common, it's not the first case. And there were several resolutions of CETENA that exempted VAs from certain type of projects and activities. And fourth, it is reasonable to interpret that if the activity is not going to be initiated or the construction is going to be initiated, we are only going to execute the easements, but no project is going to be carried on or no activity is going to start, then it was reasonable for the developer to interpret it that way.
But so just to, there is, I mean, the claimants don't really deny that there was going to be construction on there from the outset. It was their plan. And then assuming, so I'm not asking you to accept this, I'm just asking you to take this as a hypothesis, assuming that there would be confirmed wetlands in these areas that the claimants refer to as the easements, wouldn't you say that the way claimants have filed their environmental viability was precisely what Article 94 was trying to avoid, which is, in fact, avoiding that by parsing out environmental viability filing, you would mislead the administration into thinking that the land was perfectly appropriate for construction, and that would sort of smooth out the permitting process that would follow after? I mean, I'm just hypothetically.
Assuming there in fact was or is a wetland, and that SINAC had already reported that it was a wetland, and that the PNH, the wetland program, national program, had already reported that it was a wetland, and that CETENA made an inspection and reported that it was a wetland, and we went on, absolutely, yes.
Okay, and just for the record, obviously, this is what would have triggered all the inspections, right? I mean, if claimants had identified that there were wetlands there, then obviously the administration would have taken the filing seriously, because they would have realized that there were conditions to be protected on the land. But thank you very much. I have no further questions.
Mr. Byrne?
Yeah, we do have certain questions. Before moving to those very few questions, and some of them will be from my colleague, Mr. Guevara, I just need to pick up one error that has been repeated several times by Ms. Buchanaki in terms of the framing of this case and the evidence that's before you. The first time I spotted it, well, to be honest, Ms. Wood spotted it, is at transcript page 1349, line 15, but it has been introduced at a couple of other points. where Ms. Butchanaki said there are undisputed protected areas on the site. That is, the point being that they are saying that we have said there are protected wetlands. I don't know if the point extends to forests, but there are protected wetlands on site. That is a fundamental misunderstanding and mischaracterisation of the evidence submitted by the claimants and the case submitted by the claimants. We will explore this with the environmental experts, but the point in the end is there is expert evidence on our side that there are marginally hydric soils, or there is evidence of that. That is not the same thing as saying there are wetlands. You've heard a lot of evidence as to the criteria for determining wetlands. We are some distance from saying there are undisputed protected areas. So a series of questions has been put to Mr. Ortiz based on that fundamental misunderstanding of our case. I just ask the tribunal to bear that in mind.
Note is indeed taken, and this is indeed one of the issues under dispute among the parties.
Thank you. I'll hand over to Mr. Guevara now. I think he'll have a couple of questions for Mr. Ortiz. I'll have a couple of questions after that.
I will conduct my interrogatory in Spanish. Señor Ortiz.
Mr. Ortiz, could you go to tab 10, please, in your binder? Going back to the article mentioned by our counterpart, Roman numeral 213. Roman numeral 213 that says, with regard to easements, you can only segregate a maximum of 6 lots. Looking at the figure that we have on the screen and the circles that are in yellow that were made reference to, and in that order, they speak about 9 easements, and they've spoken of 72 lots. So we assume, and that is in the reality then, 8 lots per easement. But the assumption is that it would seem to be illegal that there be 8 per easement. So my clarification is then that given, or in front of those easements, there's a public road, which means that 2 of those lots, their main access is by a public road. Are you in agreement with that? So this article that says in front of the easements we can only segregate a maximum of 6 lots, we are speaking about the 3 that are on each side in front of a public easement. The first 2 would not be in front of the public easement because they're actually in front of a public road.
It says, in qualified cases, that means where there is no fronting to public roads. So when there is fronting to public roads, then there are no need for easements.
¿Y usted estaría de acuerdo conmigo?
And would you agree with me when I say that in order to establish or determine an easement, then there has to be in front of a public road?
May I just, members of the tribunal, object that this line of questions is completely leading. So he's leading the witness into the answer that he's trying to obtain.
That is correct. You should abstain, Mr. Rivera, from leading the witness into a response that is simply expected from him to conclude.
Perfect.
You understand the nature of a leading question?
Yes, sir.
Okay, so your redirect should avoid leading questions, please.
Correcto. Por favor, podría.
Could you, Mr. Ortiz, go to tab 15?
Artículo 9.
Article 94. Do you agree when I say that this article is also applicable to public administration as such?
Every time the law states that you need a permit, an authorization, an approval, or any kind of previous permit from the administration or from governmental agency, then there is an invigilando responsibility from the agencies. The agencies cannot rely, and that is precisely the idea of authorizations or permits. The administration cannot rely absolutely in the particulars because it has to do their job. They have their chores to investigate, and to make the inspections if that is the case.
Siendo así,
If that is the case, and bearing in mind that the Las Olas project had a first EV in which Setena assessed the whole property, including the easements, a project totally different, but it is with regard to that property, and bearing in mind that later a second EV was submitted for the condominium without taking into account the 9 easements, and also bearing in mind that Setena carried out 2 inspections related directly to the condominium, one with regard to a complaint made by Mr. Bucelato, where clearly in that inspection he documented the existence of 2 private roads.
Starts to be rather leading.
Let's continue, and please allow him to conclude his question first.
Inspected the site on several occasions, aware of the existence and construction of these 2 roads, and that Mr. Aven never not stated that these were related projects in his advertising. Would you agree that Setena, if it had considered that there was a violation to its authorization, should have said so?
Yes.
I'm sorry, that was leading.
Yes, Mr. Rivera, we just mentioned earlier that you should avoid making leading questions, and the nature of your last question was also clearly leading.
hipotéticamente,
Hypothetically, Mr. Ortiz, if for the establishment of an ease, the permits required by the fragmentation regulations of the municipality are submitted, and if hypothetically several easement requests are submitted at the same time, do you agree that this article should be applied by these public institutions in case they believe that its application should be required? Is there an obligation for that to be required?
Suggesting the answer to what the what the analysis of the article should be. I'm really sorry. We have to object to this.
I'm not suggesting that. I only say if it's applied for the authorities.
¿Podría replantear su pregunta?
Could you ask a question in another way? Could you rephrase the question?
You should avoid placing the response in anticipation of the witness. So if you could rephrase simply the manner of your question, I'm sure you could get the response that you are seeking, hopefully that you're seeking by rephrasing your questions.
Mr. Ortiz.
I'm so sorry.
For example, as Mr. Baker is indicating, if you could simply ask how this should be interpreted, how a provision should be interpreted without placing the conclusions in anticipation of.
My apologies, but for the purposes of this particular question, I believe he's already given the answer he wanted to obtain, though.
The exercise is hearing from the witness.
That tribunal, we ask the parties to please bear in mind that the tribunal will have the ability to evaluate any responses on the record, but in order to avoid any unnecessary discussion and in order to avoid any unnecessary and improper line of questioning, we ask the parties simply to try to abide by the rules.
So, Mr. Ortiz, thinking hypothetically about the process for establishing an easement, what provisions of law do you think would apply with respect to the public institutions who would handle those applications?
El derecho ambiental
that its principles are transversal. That means that not only SETENA, not only the Environmental Administrative Tribunal, and not only the Fiscalia, specialized in environment, are empowered to make to apply the laws. So, I mean, in this particular case of the easement, it is my expert opinion that the municipality and our constitutional chamber and our legal leading cases has said it this way. The municipality has also environmental empowerment to apply the law. In fact, if you go to the municipality and request a construction permit for a condominium project and you don't present the environmental viability, the municipality would say, no, I cannot grant you the permit. So in this case of the easements specifically, if the municipality that also has environmental empowerments thought that VA was required, then the visado municipal that it had to grant to the servidumbres would have to be denied. And if the municipality did not deny the visado, and indeed the VA was required, then the municipality would be responsible along with the developer.
Thank you, Mr. Ortiz. Before we, just going back a bit to the question of lots, and you still have the plan on site, you'll remember that Ms. Buccinaki put a series of questions to you in relation to the way in which the lots on the easements would be sold. And she asked you about essentially who bears responsibility with respect to the environmental protection for the land. Now, first of all, before lots are sold, who bears responsibility for compliance with environmental laws in Costa Rica? With respect to the land in question, that what we call in this case the easement section. Who bears that responsibility?
Okay. The developer, Setena, the municipality, and all of the Costa Rican agencies that had participation in the project.
Okay, so the fact that there is no EV doesn't change your answer. The developer is still responsible.
I'm sorry, I didn't get the question.
I just want to check that I understand your answer correctly. You said, amongst other people, the developer remains responsible for compliance with environmental law.
Mm-hmm.
The fact that for this section there is no environmental viability permit issued, do you think that changes things? Does the developer's position in law, is it changed at all with respect to liability and responsibility under environmental law?
I'll try to respond to what I interpret. If there was no EV, it is not only because the developer decided or made a reasonable interpretation that there was no need of an EV, but also the municipality accepted that interpretation, the INVU accepted that interpretation, the National Cadastre and the Public Registry, and in some way also Setena, because Setena made inspections in the project and knew that there were easements there and did not raise any red flag, did not say that there was a need for an EV.
Thank you. And after a sale of a lot, who has responsibility for compliance with environmental law?
The owner of the lot.
And what? Sorry.
And all of these agencies always maintain their duties on environmental law.
Does the activity of the new lot owner have any impact on how they might comply with environmental law?
Sure. If someone buys one of those lots and decides to drill to see if there is oil there, of course the owner would be the only one responsible.
Okay, thank you. Now you'll recall that Ms. Buchanaki took you to tab 13 of the file, which is Setena Resolution 0530-2015. This was in the context of Article 94 of the Biodiversity Law. You remember those questions that were put to you?
Yes. Yes.
Could you just look at the text, just quickly read through the text of this resolution, see if there's anything that, bearing in mind the provisions of Article 94, which you were taken to, there's any further comments you would wish to make? Any comments, Mr. Ortiz?
Not for the moment. I'm only missing the last part.
Just wonder if you have the right document there. Is it tab? It's definitely tab 13 you're looking at.
Yes, tab 13, R344.
Let me just check the R number. Yes. Okay. So, I mean, bearing in mind Article 94 of the biodiversity law, with which you're familiar, and the provisions about totality and so on, is there anything there that prompts any further comment from you? If not, that's fine. Just wanted to give you the opportunity to comment if.
No, I read it very, very quickly, so.
Okay, that's fine. Just one final question for you, Mr. Ortiz. This goes right back to the beginning, and actually doesn't arise out of anything that Ms. Buchanaki put to you, or kind of, but you'll recall that Professor Niken had some observations in relation to the Bronstein and Peru case from the Inter-American Court on Human Rights, and so on. There was, I think, with all due respect to Professor Niken, I think your initial response was being slightly cut off, and I just wanted to give you the opportunity to see whether your opinion or your comments on that case and its issues for, I think the comments you made related to ownership, but I just wanted to see if you had any further comments that you felt you hadn't had the chance to make clear on in relation to that one particular case.
Indeed, well, I agree with Professor Niken. The facts were not exactly if political rights could be discriminated or not, or if only political rights were not. But to me, to my interpretation, and with all due respect, Professor Niken, I think that the Human Rights Court does implicitly say that not only was the citizenship taken away in an illegal way, in an illegal form, because due process of the law was indeed violated, also the right of opinion and the right to press, but also implicitly the court says that discrimination in human rights is only, let's say, legal or valid when we are dealing with political rights, because that's the real sovereignty that a government or a country has. Obviously, each country can establish limitations for foreigners to vote or to participate in unions or to participate in political parties. But I also wanted to add that the European Human Rights Court has also developed this principle. I mean, obviously, in Europe we have a union, and they have also issued certain rulings in that respect, in which discrimination in regards to human rights between foreigners and nationals is not valid. I mean, you cannot discriminate dealing with free enterprise. You cannot discriminate dealing with the right to work. Our Constitutional Tribunal, for example, has stated that it is unconstitutional provision from our laboral code that says that inequality of conditions, the one should prefer the national worker and not the foreign worker. So, I mean, that's my interpretation of what implicitly, to me, the Human Rights Court said, also related to what the European Human Rights Court has also issued as legal precedents.
Thank you, Mr. Ortiz. We have no further questions.
Mr. Nikan, do you have any questions?
Yes, I would like to make a comment with regard to this last comment. There is, of course, my interest is not to, in my position, to discuss this with the expert, but I do want you to look for the word discrimination or the verb discriminate. Do a search in the Braunstein decision, and you will see that that was not an issue in that case. The word appears only once, and it is in the context of an article that is quoted and that mentions discrimination, but it was not applied to the concept. I may or may not agree with you, but in any case, I don't think that the Braunstein case applies here or applies to that you mentioned, and I just simply felt that I needed to intervene to challenge a confusion, which in my opinion is not appropriate. Now, but in any case, as for the rest, we will discuss it amongst ourselves here among the members of the tribunal, and I'm not saying that your point of view as a matter of principle is harebrained. It's just simply not part of the process. Now, the other answer, basically you answered it already, but I would like to see more precisely. You several times yesterday and today you also mentioned it, said that there should have been an EV from the time or from the moment that the municipality had seen the plans. So my question yesterday was if the municipality, in giving the authorization, had the jurisdiction to exempt from EV in case that was necessary. At one point you said that the legal consequence of that authorization is not the exemption, but the municipality would be responsible together with the developer. So in any case, I would like to ask, from your point of view as an expert, what is the legal effect of a situation where the municipality has authorized without having checked that the EV was there?
I would like to answer this question in Spanish and with the permission of the government of Costa Rica.
If there's no objection on respondents?
No objection.
Thanks.
Please.
Profesor Niken, le respondo.
Professor Nikan, I will answer. In the resolutions of Setena of 2008, to which I made reference, Setena, what it was saying basically is that there are projects that, due to the fact that they have low impact or the certainty of their impact, it should be delegated to other authorities that also have jurisdiction, environmental jurisdiction, and that was the case of the municipalities. So that the municipalities can decide that, analyze it, and then decide if this is part of the technical and legal elements that I established in the resolutions as far as exemption is concerned. So if the municipality authorizes these plans, the easements, it's not that it exempts them, but it simply interprets, according to its environmental authority, that this is a case in which an EV is not necessary. So my position is that then it becomes co-responsible because it expresses this as a state that comes up as one that says to the developer, you can be sure that you went through me. I also have environmental jurisdiction, and I believe together with you that this does not require an EV.
Gracias.
Thank you.
I have just a few. Are you aware of any, well, let me back up and set the predicate. It seems that there is a spirited competition over whether or not fractionalization or the submission of segmented land development programs is permissible or not. And you've said that this is not the only case that you have seen in Costa Rica. Are you aware, since I assume everyone in Costa Rica who specializes in these problems is aware, of any interpretation from the public administration that would say any parcel of land, regardless of size, owned or controlled effectively by a common or single developer, must have an EV on all aspects of any parcel prior to beginning any construction work? Wouldn't that solve the problem if that were in fact the interpretation? Isn't it just that clear?
Sure. There is no resolution or interpretation by any governmental agency in that sense.
Okay, my next question is a more principles-based question. Sometimes when we speak of legal regimes, I'll use the tax administration in my country as an example, we refer to that as being a regime of rules and regulations, whereas our British cousins would refer to it as a principles regime. And the difference in interpretation is that in a rules and regulation regime, basically anything that's a reasonable interpretation can fly, subject to being re-examined, whereas in a principles regime, without more detailed specificity being required, people are supposed to apply the ultimate principle rather than the technical nature of the rule or the regulation. What is the public administration's view with respect to the understanding of its environmental regulations in Costa Rica?
Definitely principles. It might be interpreted one way or the other. And in fact, leading cases have been changing and have been modified, and sometimes they refer to the precautionary principle as the preventive principle, and sometimes they refer to the preventive as precautionary. It's definitely principles. There are no exact rules or regulations established.
So from a principles-based regime, doesn't that indicate that people's conduct must be more conservative or on the safe side, since they do not have the protection of an express regulation that they're pointing to?
Yes, and that's why the legal regime establishes not only setena, but also transversal empowerments in which you cannot do, as a developer or as a particular, you cannot do anything without going to an administrative agency. So you should be conservative, but you also have the legitimate expectation that those agencies will tell you, well, your interpretation, though valid to me, your interpretation is wrong.
So that brings me to my next question, and that is, you make application to an agency. I assume the agency's duties to discharge its functions as a matter of law and regulation is not delegable. They cannot avoid doing that. They must make a decision, correct?
Correct. Indeed, Article 66 of our General Administration Act states that duties, public duties, are undelegable, and well, yeah, the answer is yes.
Okay, so after, you've taken great care to draw a distinction between before the issuance of an EV and after the issuance of an EV. And I want to make sure I understand the consequence of that distinction once the permit or the EV has been granted. Does it create rights? You've said it creates legitimate expectations, but does it create legal rights in the holder of that EV when the agency has given it in response to a plan?
Sure, that is why the Constitutional Court and the Procuraduría General de la República, and here I want to make a clarification, we tend to translate Procuraduría General de la República as Attorney General. It's not quite the Attorney General. The Procuraduría is like the General Counsel for the government. The Procuraduría has established that when you are going to declare EV as null and void, you have to follow the due process of the law.
Okay, so let me back up then. Here, we never had a situation where a permit was declared null and void. We had situations where they were injuncted. So, do I understand the fair balance of your testimony is that the wrong remedy was used by the agency? It should have been declared null and void rather than injuncted? Is that the principal thrust of your testimony?
Exactly.
All right, so if that's the case and the wrong remedy was applied, tell me, under the 15-day concept that we've been discussing, whose duty is it to come forward and point out that the wrong remedy took place? Is it the agency, who is the expert under the public administration in this, that's supposed to revise itself? Or is it the person whose rights were affected in the EV that was injuncted that has the duty to come forward and fix the problem?
Both.
Both can, but who bears the principal responsibility?
The responsibility is of the agency, and it is expressly stated in the General Administration Act, Article 194, more or less, which states that if a wrongdoing from the administration has been detected, then the administration, no matter how much time it has gone by, is obligated to annul its acts, resolutions, and conducts.
So then, is it a fair summary of your testimony for me to take away that your view is that regardless of whether the EV was properly granted, once an EV was properly granted, the duty for ending that grant through a remedy of ordering it to be null and void lies with the agency, and that is non-delegable? Is that a correct summary?
Exactly. Administrative acts are deemed valid until they are declared null and void by the procedures that the legal scheme states. Meanwhile, if you have not annulled or declared them null and void, they have to be applied.
All right, so let me press you a bit on that. You're saying that even if the injunction was not rescinded or dissolved in any way, that the public administration that issued that is in violation of its own rules and regulations? Is that what you're saying?
I'm sorry, could you repeat?
Yeah, I'm just trying to push you, and I'm going to push on the other end in a minute, to see how far your logic takes us. Are you saying that even if an injunction was issued by the expert agency and it should have been declared null and void, because it applied the wrong remedy, is that agency responsible in damages for having used the wrong remedy? Is that what you're saying?
Of course. Because by doing that way, by acting wrong, it has paralyzed or it has freezed the rights of the developer without following the legal procedure.
All right, let me go back to the back end and say, I want to explore a little bit about the contours, and this is my last set of questions, Chairman. I want to explore a little bit of the concepts about before any application has been filed. And as I understand it, as long as we are talking about a virgin property that has not otherwise been classified by one of the environmental agencies in the country, your testimony is that there is a shared duty between the developer and the expert agencies in order to ensure that that property is appropriately classified at the EV application stage. Is that correct?
Correct.
Okay, so let's just, for the sake of hypothetical, use your oil drilling example. And so let's just say that the owner of the property decides that he's going to go ahead and sink his well and do all of that, and yet when he goes to the application process, he mentions nothing about his well. And at that point, where does the duty lie? We have a paper which is obviously false because it is not complete in any real meaningful sense of the word. It's not a technical error. It's a serious omission. And the agency has what duty at that point? May they rely solely on the paper, or do they have to get out of their offices and go check what is presented to them on the paper before they go to the next step?
They have to check, and Article 94, if I'm right, of the Environmental Organic Law states as a duty of SETENA to inspect. Also, the regulations states it as a duty. I mean, this case would be very radical because the owner of the property has already begun drilling, and everybody knows, even a lawyer would know that there's drilling. But there are certain cases like a wetland that it's not that's not that obvious.
You know, I'm focusing on my extreme example, and the reason I picked the oil drilling is so for whatever reason there are no community complaints either. Maybe they're all silent partners in the oil well, so there's no third party. I'm trying to focus solely on what your understanding is of the duty of the agency to whom the EV application is made.
Once an agency has an empowerment and has been their door has been knocked by the citizen for them to empower their duties, then public agencies become co-responsible. Of course, if the developer lied when he said something that is so obvious that he was already drilling and said, no, I'm not drilling, he would be criminally responsible. But if SETENA does not inspect and comes and gets to know that 3 years afterwards that the drilling was already done, then SETENA is obviously co-responsible.
Well, and that's exactly the hypothetical I want to play out for you. So let's assume, continuing in the same example, that the agency at some point, after having issued an EV, comes out and sees that there's impermissible oil well that's on this property. As I understand what you're saying is their immediate remedy is not to file an injunction, but to cancel the EV and render it null and void. Is that right?
No. Yes, they are. They may issue an injunction because this is another case. In this case, there would be an obvious false declaration, so the EV would not cover oil drilling. I mean, if the developer distracts or deviates from the activities that SETENA has authorized, then the precautionary principle is applicable because it is not a damage that has already been controlled by the EV. So yes, it is empowered to issue an injunction, but immediately after that, if SETENA deems that the EV is null and void because the declaration was false, immediately it has to initiate an administrative procedure or else file a judicial review, a lesividad process, to annul the EV.
You've done an excellent job of anticipating my very last question, and that's this. Let's change our hypothetical just a little bit. And let's say that an owner of a property has made application because they want to build a two-bedroom house on the piece of property. And the EV is issued without inspection by the agency. And at that point, the owner builds his house and he decides, you know what, I really should have made this a three-bedroom house, not a two-bedroom house. And he never goes back to the agency, and the agency comes out just as he's finished and taken delivery of his house and says, oh gosh, you built something that you were not supposed to do. I'm trying to obviously explore the contours between the preventative principle where the actual house was built, and that was the issuance of the EV, but the size of the house may have been slightly larger, or the configuration. Is that the type of issue where a precautionary principle would be applied, or would it be something else?
That's a great question because it lets me explain that the precautionary principle is not what Don Quixote called the bálsamo de fierabras, medicine he had for everything, for every hurt he had, Well, the precautionary principle is not the bálsamo de Fierabras and it is not valid to apply it in any case. Proportionality and rationality principles have to be taken into consideration. So if that is the case, a two-story house or a three-story house, I don't think technically that would make any difference in the harm to the environment. So issuing an injunction because the person built a three-story house and not a two-story house would be definitely unreasonable. However, if this person built an office building of 15 floors, definitely the precautionary principle would be reasonably applicable.
Thank you very much. Thank you, Chairman.
I'll abuse your patience and that of the court reporters and interpreters just for a few more minutes. I have two basic questions. One deals with what I believe is one of the key issues in this proceeding. As I understand, one of the allegations from the Republic of Costa Rica is that this project was a project that should be viewed as a whole, as one, to be developed in different stages. And you've heard line of questioning, and you've probably read in the materials in this arbitration that this project was one project to be developed in several stages. You may or may not be aware of the allegations that some of the alleged wetlands are located in the western, southwestern portion of the property, which is, coincidental or not, located in the easements area. If you look at the map that is behind me, you will see that the alleged wetlands are located essentially in the area where the easements are located. And as I understand, one of the arguments in the arbitration by the Republic of Costa Rica is that the fragmentation of the property was done with a purpose, and the purpose was to avoid having an EV, precisely because Costa Rican law would allow the fractioning of that property without the need to submit an EV. Why? Because there was to be 9 different fragmentations in different easements with 8 lots. It's not an issue whether it's 8 or 6 lots. Let's keep that aside. And you have testified that this was a legitimate petition on the part of claimants that they could receive a permit to develop these easements. Now, the argument on the part of the Republic of Costa Rica is that this was not and should not be viewed as a valid application nor permit and avoidance of an EV because precisely Article 94 of the biodiversity law requires that the project be viewed as a whole, which would mean that at the time that even the easement section was applied for, they should have, meaning the developers, should have presented the complete picture and the issues under a D1 to secure an EV, even though viewed in a fragmented manner, the easement section did not require one. Please interpret Article 94 in this context. Well, first of all, did you follow me? Did I make myself clear when I described what I interpret this particular dispute to be?
Mm-hmm. Yes. Okay, let's see. On the wetland, even though it is casualty that it's in the same part of the property as the easement, what is true?
And just for purposes of the record, when you say the wetland is, I assume you refer to the alleged wetland because
exactly.
Your counsel
has the alleged wetland, the supposed wetland, the hypothetical wetland. What is true, it's that Setena, when you file the request for the EV, you have to file what it's called I don't know if I'm going to translate this well or not, a cartographic map. The government of Costa Rica has alleged that everybody knows that there are wetlands or that there are alleged wetlands or supposed wetlands in Esterillos, and that it is obvious that there are wetlands. Well, with this cartographic map, Setena must have had raised the flag because it is so obvious that there are wetlands in Esterillos. The municipality made inspections in the whole project.
Yes, but my question relates more on the interpretation, a legal interpretation of Article 94 in the context of this
okay, I got you. Yes, I'm
lack
sorry.
of understanding this dispute existing among the parties.
Okay, I'm sorry for my deviation. What I said it at the time when the easement was executed, it was a reasonable interpretation because there were at least 3 resolutions by the Setena that exempted VAs from certain kind of projects, and I would say that delegated the acknowledgement of the project to each of the municipalities to determine if in fact it needed a VA or it did not. And under that reasonable interpretation was that that developers decided or interpreted that just for the execution of the easements, not for the execution of the project itself or the construction itself or the initiation of the activities, it was not necessary a VA. So they decided to submit their application to the municipality, who also determined that there was no need of a VA. So my position is that it was a reasonable interpretation that was in fact confirmed by the municipality, by IMBU, at least by those 2. Also bear in mind that the municipality had made inspections all over the place, all over the project, and that SINAC had already released its reports stating that there was no wetland in the property. So I think it was a reasonable interpretation based on resolutions that were in place during that time by Setena that exempted certain kind of projects from going to a VA, and that there were, and this is to me the most important part of all this case, there were not one but several reports from SINAC, which is empowered to overview wetlands, that said there are no wetlands here.
And this would, because one of the issues also in dispute is whether or not these EVs that had been issued under lack of information that had been disclosed by developers. This is, one of the parties alleges, naturally the Republic of Costa Rica alleges that it was the responsibility of developers to have disclosed the existence of whatever information there was, and whether these could be flooded areas that should not be considered as wetlands, but somebody could take the position that they were, that this is the information that should have been disclosed. What your testimony as legal expert is that it was the responsibility then of Setena, SINAC, and even the municipal authorities to make the inspection and ascertain whether or not there was a wetland. And the fact that they did not, then this was a, following a response you gave to Mr. Baker, this was an acquired right of the developers. Did I interpret this correctly?
Yeah, and moreover, what information was missing on the part of the developer if SINAC had issued at least 3 reports in which it said there were no wetlands? So what is the lack of information? I mean, the public entity that is empowered to overview wetlands had said there is no wetland. And from my attorney point of view, I think it is not easy to determine where is a wetland and where there is just a flood. I mean, my backyard sometimes floods and it is not a wetland. So it is not an obvious.
I agree. I don't have, I think you and I as lawyers can apply the terms of the regulations that establish what the 3 elements under Costa Rican law that are required to deem that there is a wetland. But what I understand that wetlands might be temporary in nature. This is that they do not need to be permanent. This is that the presence of water does not need to be permanent. It can be temporary. And maybe this is during the wet season there is water. During the dry season there is no evident presence of a wetland. I'm not saying that that is the case because I have not visited the property, but that's what the regulations, my understanding, do provide, that the conditions might be temporary or permanent in nature. If an application is made during a dry season and during the wet season, then the flooding exists and the conditions to deem that there is a wetland, how would that change the responsibilities of the developer? Or do the responsibilities of the developer change in light of the fact that there was an inspection, say, during a dry season?
Once again, I would have to go with what I just told you. To me, the important part here is that there were reports from SINAC and that it was not obvious neither for the developer, neither for the agencies. SINAC, INTA, the PNH, and many other agencies issued contradictory reports, and there are many more reports that say that there is no wetland there than there are reports that say that there is a wetland. So it is a technical issue that I cannot go and hypothesize if it is in fact, if it floods in the invierno or it does flood in the verano, if the developer could have had determined if there is a wetland or not. To me, the important part here is that there were reports of the empowered and the competent agencies that said there are no reports, and that Setena had the exact localization of the project, and if it was very obvious that there are wetlands there, then Setena had the duty to go and inspect every time. In every project, Setena has the duty to go and inspect. So that is my position.
Okay. I have one last question, and this deals with what I construed you to say, that the Constitutional Court in Costa Rica has ruled on the subject of the treatment of nationals and non-nationals in a different manner. And perhaps this was during your presentation yesterday evening or earlier this morning, but I think it was the former, where at least I understood you to say that even the requirement of having a majority of Costa Rica national participation in the capital stock of a company in a terrestrial maritime zone should be deemed to be unconstitutional. Was this your position? Is it your argument that if an authority should come in and say that it was unlawful for somebody like Mr. Aven to hold more than 50% in the capital stock of La Canícula, that should be treated by the constitutional courts in Costa Rica as unconstitutional? Because an American citizen, or Italian for the matter, whatever nationality one would have, should not be treated differently than a Costa Rica national.
To me, that is unconstitutional because we are dealing here with free enterprise and other fundamental rights. And I have to make two precisions. First of all, the Constitutional Chamber has been, or the parties, certain parties have submitted for constitutional writs against this article. The constitutional...
Which article, I'm sorry?
The article that states that Costa Ricans have to have majority of the shares.
ZMT, la zona
exactly,
marítimo terrestre.
CMT.
Okay.
The Constitutional Chamber has rejected, but for procedural reasons. So the Constitutional Chamber has not issued any, at least not from 2000 to today, has not issued any ruling on that. And it's important, remember our civil code states that the laws have to be interpreted in the context of history. If you study Costa Rican CMT concessions, we have Marriott hotels, we have Four Seasons, we have Spanish hotels. Do you think that Costa Ricans are really the owners of the 51% of the shares?
Well, remember that many hotels only manage rather than own the asset.
Mm-hmm.
Many of these hotel chains manage, not own, because of capital reasons.
Exactly. But in many of those cases, they are really the owners. At least the experience I have with my clients, those two, one of those it's my client, but not the Four Seasons. But the experience I have with my clients, I mean, you have to interpret the law in the context of history. That perhaps in 1965, when the sovereignty of the countries was very empowered in people, may have had some rationale. But today, we are a global world in which there is no rationale in having discrimination amongst foreigners and Costa Rican citizens. I mean, not even in political rights at a local perspective.
Yeah,
if
that's outside of the scope of this arbitration.
Sorry, I'm a little passionate about that
Thank you
topic.
very much. Is there any clarification that the parties may wish to make on the topics addressed by the questions of the tribunal?
No, sir.
Thank you.
Yes, if we may have just a few follow-up questions and clarifications that we can ask on his
Would it be
responses.
more than a couple of minutes? And the reason I failed to notice that we haven't granted the court reporters and interpreters a break, but if it's a very short questioning.
I'll keep it short.
Okay.
So one clarification, it is not Costa Rica's position that everyone knew or everyone should have known that there were wetlands located on Las Olas. So I think that is a misunderstanding on the part of Mr. Ortiz. Then if I could please point you very quickly to Article 44, if you can put it on the screen, of the Reglamento General sobre los procedimientos. It's the regarding the assessment, the evaluation impact assessment, and I just wanted to ask you if you confirm and if you maintain your position that Setena has a duty to inspect, because this article, in fact, rather says that Setena
Yes.
it is not a compulsory.
If I may have my law with me, I can answer.
It's.
I
right
need the
there
law,
listed.
the organic law, not the those are the
So
regulations.
the organic law should be in tab.
I have it here. If I
No, it's in your binder. But it's really the tab 1. It is. Just-
Just for the record, can I just check what exhibit number the document is that you've handed
It's
up?
R238,
Thank you.
because
This is
isn't
a
it
true
the case
exercise in
that
eyesight.
isn't it the case though that the site visits are not compulsory, and that there are
yes, may I have my law? I need my law because it
I
is.
think that unfortunately, you have to rely on the documents that have been submitted as they have been submitted
Okay.
In the proceedings.
So give me just a second so I can verify.
The question to clarify is that isn't it the case that the site visits are not compulsory for Setena in this process of environmental assessment?
If you read that article, that's what it says. But the organic law of the environment says otherwise. And another executive decree that it's the reorganization of Setena says otherwise.
So you disagree with this particular article, and we
Yeah,
can move on.
that's a regulation and it's
Okay.
contradictory with the law that has a higher hierarchy.
We'll just move on.
Do you recall which article of the organic law it is?
I cited yesterday the article and the regulations, the executive decree.
No, if it's part of your,
Sir, if I could be permitted to lead on this one point, I think I can suggest a number. And
if it's a number, I don't think there's an objection on the part of the tribunal.
Fine. Mr. Ortiz, would the article of the law be Article 84?
Let me check. Yes, Article 84 states, duties of the technical secretariat. The duties of the National Technical Environmental Secretariat are the following. D, carry on the in situ inspections corresponding the corresponding in situ inspections before issuing its resolutions.
This describes the competencies, right? So that's funciones, right? It does not say what the obligations of the authorities are. Do we agree on this?
On administrative law, we are not. We talk about potestades or competencies.
That's right.
Obligations are for particulars. So when you have precisely Article 66 of our Administrative Act states that competences or empowerments are indelegable. So a competence means, because of the rule of law, because of the legality principles, means an obligation by the government agency.
So, yeah, and we will probably have to disagree on this because potestad is what an administrative body can do, not what it shall do. And I believe wouldn't you say that the formulation would be different?
Well, you can also read Article 13.0 of Executive Decree 36153, that it's the reorganization of Setena, in which it also states that it is an obligation, it's a must.
Let's move on. So, would you say that the suspension of an EV rather than a revocation actually gives the developer the avenue to correct the conduct that gave rise to the suspension and then continue once the conduct is corrected, rather than, if you're suggesting that it should have been revoked, wouldn't that then entail that once the conduct is corrected, the developer would have had to restart everything, the whole environmental viability process anew?
So, can I just put down a marker? These are questions that that Ms. Buchanaki could have put in the original cross-examination and really ought to have done. I'm not going to object on this occasion, but if it continues, I reserve the right to object.
Mm-hmm.
Yeah, I think it should only be clarifications to the issues addressed by the tribunal.
Right, it was just going to the question, his response to the question of Mr. Baker, where he was asking whether he was, what his attack against this was, that it was a revocation, it was a suspension rather than a revocation.
Okay, then that's fair.
Should I answer? Yes. You're getting it wrong. What I said is that injunctions may be ordered. A principal procedure, either to sanction the party or either to declare null and void the administrative act, has to be initiated within a reasonable time, which our constitutional chamber has stated in 15 days. To me, to my personal opinion, 15 days, it could be 2 months, but it's a reasonable time. Because remember that the injunctions are instrumental. Injunctions are not a procedure. So once you have ordered an injunction, you have to initiate either a judicial review or either an administrative proceeding. And yes, while the administrative proceeding is taking place, if the developer considers that it has to adjust to another plan, or it has to, I don't know how you called it, he might. It is not that the cancellation or the revocation or the annulment of the act, it's immediate. It would take at least 1 year, and that's why the injunctions are ordered.
Okay, thank you. Now, just my last question. Are you aware, you mentioned in response to one of the questions of the tribunal that there would be damages awarded for the situation that you were describing regarding, the revocation, and are you aware of damages awarded for situations where an agency took too long to initiate a process, for example?
Sure. At least the 4 cases I cited from the Constitutional Chamber, the Constitutional Chamber also condemned the agency to pay damages.
So if the circumstances warranted, there are procedural avenues for the developers to seek damages in Costa Rica, correct?
Well, as a general principle, I don't know if in Costa Rica or in arbitration
what
or
you're saying is
wherever. Yes, the substantial law, once the agency has been condemned, is that he can claim damages.
And likewise, if the in relation to the questions on the concession, if the developers, if Mr. Aven considered that that Article 47 was of the ZMT law regarding the 51% rule ownership, the 51% ownership rule. If he considered it to be unconstitutional, he did have an avenue to raise its lack of constitutionality, did he
No,
not?
in that case, there is no avenue because you have to go to the Constitutional Chamber and challenge a law. You have to have what we call a precedent case. So the issue should be being discussed either by way of a judicial review or either because the municipality initiated a proceeding to cancel that concession. And that is not the case. The municipality has never even raised the issue. So Mr. Aven does not have a precedent case which he can use to go to the Constitutional Chamber and challenge the law.
But, and in this case, are you aware that Mr. Aven never disclosed his dealings in relation to the ownership of the concession to the municipality?
I'm not aware of that.
Thank you. No further questions.
Okay, thank you very much, and appreciate as always the patience of reporters and interpreters. So we should take a 15-minute break. Okay, and we will continue with Mr. Jurado. Thank you.